Article 39 is primarily concerned with distributive justice. It lays down the principles of policy to be followed by the state in order to achieve this objective. Now, Article 37 states that although provisions contained in this part, that is Part 4, Directive Principle of State Policy, shall not be enforceable by any court, but the principles laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. This means that these provisions are not enforceable, however, they are to be considered fundamental by the state while formulating policies. Therefore, Article 39 occupies a prominent place in policy formulation of the state. Now let us elaborate upon these clauses individually. Article 39A ensures right to livelihood. This is not to be confused with right to work. Livelihood is a person's means of supporting himself, whereas right to work involves a particular profession, trade, or occupation. Until 2005, it was interpreted by the court as not to deprive the means of livelihood, as in Olga Tellis case. In 2005, Narega legalized livelihood security. Now let's move towards a very important article, Article 39B and C. Article 39B and C form a very important component of the DPSP. It is to be noted that the Parliament attempted to accord precedence to directive principles over fundamental rights, but the court in Minerva Mills case did not let it happen. However, validity of Article 39 Clause B and C, which aims at distribution of ownership and control of material resources and preventing concentration of wealth in the hands of a few, was upheld. In Abu Kavur Bai 1984, Supreme Court interpreted the term material resources to include natural, physical resources as well as movable and immovable properties. Thereby, nationalization of transport was upheld. Coal has been held as vital national resource for energy in Sanjeev Coke Manufacturing Company, and its nationalization was upheld. Recently, in Center for PIL, spectrum has been held to be natural resource, which has been defined as containing elements which have intrinsic utility to mankind. Thus, Urban Land Ceiling Act, Zamindari Abolition, Land Reforms Act were all intended to prevent concentration of wealth and realize distributive justice. If we consider Article 39 Clause D, it ensures gender equality in the matter of salary and pay structure for equal work. Here, the Remuneration Act 1976 was a legislative attempt in this direction. In Randhir Singh, the court raised it to the status of fundamental right by construing Article 14 and 16 in the light of Article 39 Clause D. However, an exception to this rule was engrafted in Suryanarayan Sahu versus CSIR 1998 on the basis of difference in degree of responsibility, reliability, and confidentiality. Discrimination was allowed. Under directives, Article 39 Clause E and F, welfare of children has been accorded primacy. So, employing children below 14 years has been made a cognizable offence. Children between 14 to 18 years have been prohibited from being engaged in hazardous and dangerous activity.